Hello everyone. Welcome to another episode of our channel Law Point. This is Renu Thomas, your host for this episode. At some point in our lives, each one of us would like to buy a new property or sell our existing property or sometimes do both. But without any previous experience, there are chances of making mistakes. So what are the different do's and don'ts that one must be aware to execute a smooth property deal? We have with us a Supreme Court of India's advocate on record, Mrs. Praseena Elizabeth Joseph, to explain the same. So let's watch this episode.
Sale means it is the transfer of ownership from the buyer to the seller for a price. This price is called consideration in legal terminology. If there is no consideration or there is no price paid for the transfer of ownership from one person to another, then it cannot be called as a sale, but it can be considered as a gift. For sale of a property, house, non-agricultural land of value which is more than 100 rupee, then the sale can happen only through a registered sale deed to be registered at the sub-registrar office where the property is situated. While registering a property, stamp duty and registration fee which is fixed by the concerned state government need to be paid, and it is normally paid by the buyer. Generally, before registering sale deed, the buyer and seller enter into an agreement for sale laying down the conditions to be followed by the buyer and seller before the execution of sale deed. For example, if the price or the consideration amount is to be paid in installments, then what is the advance amount paid, what is the installment amount, then the dates on which this installments would be paid, and if the buyer is intending to take a bank loan, then the details of the same, etc. Once the conditions prescribed in the agreement for sale is fulfilled, then the buyer and seller can register the sale deed. After completion of sale, seller hand over the possession of the property as well as all the original title documents to the buyer. It is important to note herein that the seller must be a person who is competent to enter into a sale deed. That is, he must be a person above 18 years of age and he must be of sound mind. Now let's see the responsibilities of the seller before execution of sale deed. The seller need to disclose or reveal to the intending buyer if there is any material defect in the property or title to the property, or if there is any legal proceeding pending with respect to this property which can come in the way of sale of this property. The seller need to show the original title documents of the property to the buyer. The seller is bound to pay the electricity, water charges, property tax, other government dues and fees up to the date of registration of the sale deed. Now let's see what are the things the buyer need to check before entering into agreement of sale. First of all, the identity of the seller selling the property need to be checked. If a power of attorney holder is selling the property on behalf of the original owner, then make sure the power of attorney agreement authorizing this power of attorney holder is registered and it contains a clause authorizing the power of attorney to sell the concerned property. If the seller is a company, trust or partnership, then the constitution document of these entities need to be verified and see whether it authorizes sale of this property, and also the representative of this company, trust or partnership is duly authorized to sell. Secondly, verify the original title documents of the property. If it is a resale property, then the original registered sale deed of the property as well as previously recorded agreements relating to the property need to be checked. If the seller has obtained the property through a will or a grant from the government or through a partition deed or through a succession certificate, then the succession certificate, partition deed, will, grant, etc. need to be verified. Thirdly, check the last paid property tax for this property and in whose name the property is mutated in the property certification of the government. Fourthly, check the latest electricity bill, water charges, etc. and need to verify whether the same has been paid by the seller. If there is any bank loan towards this property, then see to it that the seller clear outstanding loan amount and collect no objection certificate from the bank and also the original title documents of this property. Finally, check encumbrance certificate of this property from the sub-registrar's office to see whether this property was mortgaged or offered as a security for any loan or whether there is any court attachment to this property. Thank you.
Thank you for watching. Meet you in the next episode. Till then, stay tuned.